Hello and welcome to this MBL Seminars webinar with me, Clive Smith. Today's webinar is called In It Together, where we will be discussing the law in relation to conspiracy and joint enterprise. As you can see from the welcome slide, I'm a barrister. For those of you I've not met previously, I'll just introduce myself for a moment. I've been in practice for a little over 20 years now. I was called to the bar back in 2003 and was in practice until 2015, doing predominantly criminal defence work. In chambers in London, and did everything from road traffic and shoplifting to rape and murder and firearms, and plenty of joint enterprise cases and quite a few conspiracies as well. And so I hope to pass on the benefit of my knowledge and experience to you today. So in terms of what we're going to be looking at today, let's just have a look at here. Two broad aspects, as I say. Firstly, the law on conspiracy. And I wonder how many of you might be able to answer already the questions that are on the screen, or whether you're waiting to see what the answers are in a few moments' time. But some of the questions, for example, we're going to be considering today are things such as, how might I withdraw from a conspiracy? What if a different offence to that originally agreed on is committed? Am I still guilty of conspiracy? And then secondly, we'll turn to the issue of joint enterprise, and of course the very well-known case now of Jogee, and consider what's changed to the law, what changes to the law this made, and consider or reflect upon where are we now. Okay, so let's make a start. So firstly then, as many of you will know, I'm sure, the law in relation to conspiracy can generally be found in the Criminal Law Act of 1977. The Criminal Law Act put the offence, what was previously a common law offence of conspiracy, onto a statutory footing. Whilst it replaced the common law offence of conspiracy, it did, however, preserve the offences of conspiracy to defraud and also conspiracy to do acts tending to corrupt public morals or outrage public decency. I'm not entirely sure why it preserved those two specific offences as common law offences rather than make all offences of conspiracy statutory. If you do know, then answers on a postcard. I'd be intrigued to know what the rationale was as to why those two offences were singled out for special treatment, were reserved or preserved in terms of them being common law offences. So there we are.